Hello and welcome to LifePlan Legal Arizona's Estate Planning, Elder Law, and Probate Q&A. Today's question is a probate bond required in Arizona? This is another great question. It is not a question I'm often asked, I suspect because most people have never thought about it. So let's dive in. What is a probate bond? A probate bond is one type of court bond that is used to ensure that the deceased person's wishes are carried out ethically and correctly. The bond is a way to make sure that if an error happens, that the beneficiaries of the estate are compensated for any money lost. Other names for a probate bond you may hear include estate bond, executor bond, or fiduciary bond. And there are a variety of types of probate bonds, depending on whether the case is a guardianship, a conservatorship, the probating of a will, or legal custody of a minor. A few examples include an executor bond, when the deceased leaves a will naming a person as personal representative, an administrator bond, when the deceased dies without a will, also known as intestate, or a trustee bond, if a will leaves assets to a trust. How much does a probate bond cost? The cost is dependent on a number of factors, including the value of the estate and the risk factors being protected. As long as no action is taken that harms the estate, the entire bond amount is returnable. However, unless you have enough cash to post the bond yourself, you may be required to seek out a professional bond issuer. And the fees associated with securing a bond could cost anywhere from 0.5% of the bond amount to much more if you're considered a high risk because of low credit or otherwise. All right, so must you have a bond? By statute in Arizona, a bond is always required unless, 1, there's a valid will expressly waiving the need for a bond. If you hire LifePlan Legal to work on your estate, we will include that provision in your will unless you have a need to require a bond. 2, another time when a bond will not be required in Arizona is if all heirs or all the devisees sign a written waiver of bond with the court. And 3, a bond is also not required if the personal representative is a national bank or title company with a certificate as a public fiduciary. If you're unsure if a bond is required in your situation, call our offices for a free 30-minute strategy session. The last thing I'll address is who gets the bond. When a bond is required, since the bond covers the actions of the personal representative, sometimes called the executor of the estate, it is his or her responsibility to obtain the bond. Ultimately, it is the court's decision of who needs a bond and how much of a bond is required. Generally, the higher the risk, like if the estate value is high, or the greater the freedoms of the ward at risk, like in a guardianship or conservatorship case, the more likely it is that a bond will be required. For more information on probate, guardianship, or conservatorship, or creating a valid will in Arizona, visit www.lifeplanlegalaz.com. I hope that you enjoyed this week's Q&A. Before you go, let me invite you to support our mission of helping 10,000 Arizona families prevent conflict through proper estate planning. If you or somebody you love would like to join our growing family of 5-star happy clients, schedule your free strategy session by calling 602-910-4068 or visit lifeplanlegalaz.com. Don't forget to subscribe.